Modern Real Estate Practice, page 378. Property manager will make the decision on what is most cost effective for the owner. This decision should be based on a number of factors, including the size of the building, complexity of the tenant's requirements, time and expense involved, and availability of suitable labor. A commercial or industrial property manager often is called on to make tenant improvements or build-outs. These are construction alterations to the interior of the building to meet a tenant's particular space needs. Such alterations range from simply repainting or recarpeting to completely gutting the interior and redesigning the space by erecting new walls, partitions, and electrical systems. Tenant improvements are especially important when renting new buildings. In new construction, the interiors are usually left incomplete so that they can be adapted to the needs of individual tenants. One matter that must be clarified is which improvements will be considered trade fixtures, personal property belonging to the tenant, and which will belong to the owner of the real estate. Modernization or renovation of buildings that have become functionally obsolete and thus unsuited to today's building needs is also important. The renovation of a building often enhances its marketability and increases its potential income. At the same time, federal and state regulations regarding lead-based paint, asbestos, and other hazardous substances that may be found in or around a structure can entail expensive remediation efforts. Environmental concerns. The environment is an increasingly important property management issue. A variety of environmental issues, from waste disposal to air quality, must be addressed by the property manager. Tenant concerns, as well as federal, state, and local regulations, determine the extent of the manager's environmental responsibilities. Property managers are not expected to be experts in all of the disciplines necessary to operate a property. They are expected to be knowledgeable in many diverse subjects, most of which are technical in nature. Environmental concerns are one such subject. Recycling facilities may be required by law, but even they are not. The manager may want to provide them for tenants, which can benefit the environment, as well as make the property more marketable. Hazardous wastes produced by employees or tenants must be properly disposed of. Even the normally non-hazardous waste of an office building must be controlled to avoid violation of laws requiring segregation and recycling of types of waste. Resident property managers of buildings constructed before 1978 must provide lead-based paint disclosure forms to all new tenants. Environmental audits also identify issues relating to asbestos, radon, and mold. Air quality issues are a key concern for those involved in property management and design. Building related illness, BRI, and sick building syndrome, SBS, are illnesses that are more prevalent today because of energy efficiency standards used in construction that make buildings more airtight with less ventilation. BRI is a clinically diagnosed condition that can be attributed directly to airborne building contaminants. Symptoms include asthma, hypersensitivity, and some allergies. SBS is more typical in an office building, and symptoms include fatigue, nausea, dizziness, headache, and sensitivity to odors. Often increasing ventilation or replacing interior features such as carpeting can solve air quality problems. Construction involves making a property meet a tenant's needs. Page 379. Federal laws prohibiting discrimination. Federal laws prohibiting discrimination in the provision of housing, accommodations, services, and access to credit affect the property management profession. The Americans with Disabilities Act, the Equal Credit Opportunity Act, and the Fair Housing Act all help to ensure that consumer rights are not violated. The Americans with Disabilities Act. The Americans with Disabilities Act, ADA, www.ada.gov, has had a significant impact on the responsibilities of the property manager in both building amenities and employment issues. ADA Title I provides that any employer of 15 or more employees must adopt non-discriminatory employment procedures. In addition, an employer must make reasonable accommodations to enable an individual with a disability to perform essential job functions. Property managers also must be familiar with ADA Title III, which prohibits discrimination in commercial properties and public accommodations. ADA requires that companies ensure that people with disabilities have full and equal access to facilities and services. See Figure 19.1. In practice, a prospective tenant is visually impaired. The property manager should be prepared to provide a lease agreement that is in large, easy to read, type, or that is printed in Braille as required. Figure 19.1. Reasonable modifications to public facilities or services. Provide doors with automatic opening mechanisms. Install an intercom so customers can contact a second floor business in a building without an elevator. Add grab bars to public restroom stalls. Provide a shopper's assistant to help disabled customers. Provide menus and real estate listings in a large print or Braille format. Lower public telephones. Permit guide dogs to accompany customers. Provide ramps in addition to entry stairs. www.ada.gov.